for the next 30, at most 40 minutes. In these slides, we'll be discussing mostly about lawful data retention, but also balancing compliance between the Data Protection and Privacy Act and industry-specific regulations. Now, this presentation is particularly important because when you read the relevant law, Section 18 of the Data Protection and Privacy Act, it provides that a person who collects personal data shall not retain it for a period longer than is necessary to achieve the purpose. Now, that clause is very broad, and yet in certain industries, and that will be the second point of our discussion, okay? For instance, the medical industry, the banking industry, the telecommunications industry, there are specific guidelines and regulations on how long data should be retained. So the second element of this presentation will build on. I'll begin by giving an overall legal framework on data privacy. You can't speak about retention without understanding the basis for collecting data, because as you will know, the two are linked, especially through the purpose for which data is collected. If you're collecting it for this purpose, then you can't retain it for a period that is longer than that purpose. Then the third element will sort of like synthesize what's the overlap between sector-based regulation and how it interfaces with the data protection regime. And I believe the two are complementary, especially because I'm very well aware that when the Data Protection and Privacy Act was being drafted, they were mindful that in certain sectors, they could make regulations on how long data should be retained because of the uniqueness of those sectors. So that's a brief overview of the presentation, and I'm extremely excited to be a part of this conversation. Like I was introduced, I'm a senior associate and a head of technology at H&G Advocates, and I'm very pleased to be here. So to dive right in, legal framework. We always, as lawyers, we have to begin from the point of legal framework. And I think even everyone as a data protection officer, you have to know the legal framework under which you are operating. So in the first couple of slides, I'll speak about the general legal framework for retention of data and collection of data. Then I will go in specifically on retention. Then we shall segment into industry-specific regulations. So in terms of the legal framework, it goes without saying, Article 27 of the 1995 Constitution guarantees the right to privacy. And then there are several other laws that apply, the Data Protection and Privacy Act, the Data Protection and Privacy Regulations, and then they are different sector-based regulations that tell you they don't comprehensively deal with data protection, obviously, but they tell the licensees in those sectors how long they should retain that data. And so we'll also look at those. But in detail, Article 27 of the Constitution provides for the right to privacy of a person, home, or other property. It prohibits unlawful search of a person, but most importantly, it restricts the interference with the privacy of a person's home, correspondence, and communication or other property. And then the Data Protection and Privacy Act operationalizes the entire regime on data protection. I also am very well aware that some of the organizations that you represent have international obligations on privacy. And so it is very possible. I was interfacing with a client and we are very well aware that they have obligations locally and internationally because they also offer services to companies that are based elsewhere. So in certain restricted instances, international regulations may apply. For instance, general data protection regulations, and also like the California Online Privacy Regulation. And we've seen a number of cases that have affirmed that if one is providing services to people in another country that has a legal regime, it is likely that that legal regime is going to apply. So the key decision of Schrems versus Data Protection Commissioner before the European Court of Justice also expounds on that. So that's mostly the legal framework that creates the regime by which data protection is considered. And so you really have to think about it as a data protection officer. The Constitution applies, the Data Protection and Privacy applies, but also if you're offering services to people that are from a different jurisdiction and that their applicability provision extends towards you, you also have to be alive to those obligations. Some key definitions, I think it's always important. And again, we can't assume that these definitions are common knowledge, but privacy usually represents an individual's control over their personal information, including identity, creditworthiness, health, and more. So they could be personally identifiable information that has attributes that communicate one's health, one's creditworthiness, one's own identity and roots. So privacy and data protection pertain to all those areas. But also, it also signifies the limited access to one's own personal information. And so this regime entails collection, retention, control, and processing. Now, today's discussion is going to focus a lot on retention, which is after you have collected the information. But you will see that there is a link between collection and retention, because the requirement is that you must collect information that is for a specific purpose. And that ancillary obligation follows for those who are going to retain the data. How long can you retain it? You retain it by asking, for what purpose did you collect it? And how long do you need to achieve that purpose? Okay? And then what's personal data? Again, we have to define these clauses because in most instances, there can be a misunderstanding on what amounts to personal data. But according to the Data Protection and Privacy Act, the interpretation section, it is information that can be used to identify an individual, and it could be recorded in any form. So privacy is a fundamental right, and it's essential to the autonomy and the protection of human dignity, serving as a foundation upon which other human rights are built. Okay, so at this point, I think it's important to know, and I know most of you might know it already, but the Data Protection and Privacy Act applies to any person in any part of the world that collects and processes information relating to Ugandan citizens. That's key. That means regardless of wherever you are, if you are collecting data and you're processing data or you're holding data that relates to Ugandan citizens, the scope of this law applies. And that's similar to the point I was making earlier on application of international regulations. Most of the international regulations have a similar provision. So that means a law can apply to you even when you're in a different country. But also the law applies to any institution or public body, and that includes public bodies that collects or processes information within Uganda. So there's a requirement for physical presence in Uganda. But even when you're not present here, as long as you collect data that relates to Ugandan citizens, then the scope of this law applies. And that means whatever we're going to discuss on collection and retention would extend towards you. So it's always important to ask yourself, are you a collector? Are you a controller? Are you a processor? Okay. And these are all, again, defined within the law, very, very specific definitions, which I think are of interest to most of you. One, the regime would extend to you if you are collecting. Collecting is self-explanatory, means the person who collects the data. But a controller usually will be a person who alone, jointly, or with others, or in common purpose with others, determines the purpose and the manner in which the personal data is processed. Okay? And then the data processor is a person who processes the data on behalf of the controller. And the data subject is the person who has granted you that information. Now, a lot of these terms may sound very, very legal, but it's always important to ask yourself, in what capacity do you operate? Because each of these people have an obligation. A data subject has rights. So even as we think about retention, we have to begin understanding it from the perspective of who are the key people that are regulated under this. And now it goes without saying that the principles for collection and processing of data are: one, you must be accountable, it must be lawful, and we'll speak about lawfulness, especially pertaining to retention, because there are specific industry and sector-based regulations that deal with some of these areas. And then there's also relevance, and you must only collect information that is necessary. And then in terms of retention of data, you must retain data for the period that is authorized by the law. Okay. And I think that it goes without saying that for most of us who are on this call are actually aware of the fact that that the regulator is the Personal Data Protection Office who has convened this event. And it's very important for us to keep that in mind. In any sector, and I keep on telling as I interact with clients, it's very important to know who is your principal regulator. If you are a financial institution, you have a principal regulator in Bank of Uganda, and you also have a principal regulator in the Personal Data Protection Office, because you also collect personal information. So it goes without saying that that the Personal Data Protection Office has the mandate, and it's the principal regulator on questions of data protection. And therefore, where there is any query or complaint, as the law provides, those complaints must be made to the relevant statutory agency. Now we're going into data retention, which is why we are here. Data retention is provided for under Section 18 of the Data Protection and Privacy Act. And Section 18 is very, very specific. I've summarized it here because, again, this presentation is only meant to give you a general understanding. And I don't need to put all the provisions of the law here. Otherwise, I could have copied and pasted the provisions of the Act. But the key principles on data retention: a personal data must not be retained for longer than the period authorized by the law, or longer than the period that is necessary for the purpose for which the personal data was collected. And I'll read verbatim from Section 18. It says, a person who collects personal data shall not retain personal data for a period longer than the period that is necessary to achieve the purpose for which the data is collected. Okay? So, and that was the starting point of this presentation. Why are you collecting this data? If you're collecting that data specifically for a certain purpose, that has an input on how long you're going to retain that data. And that's very important. But also, another condition for retention is it must be authorized by the law. If it is not in specific to your purpose, it must be authorized by the law. And today's presentation is going to focus on a few selected sectors. Now, there are so many sectors that and industries that exist, but we'll focus on them, some of the main sectors that are identified that have specific data retention requirements and rules, which can be interpreted alongside the Data Protection and Privacy Act. Now, this is not a contradiction to the Data Protection and Privacy Act. Actually, the Data Protection and Privacy Act, when it was drafted, it was mindful that there are certain sectors, like the health sector, the banking sector, which may have, because of the nature of information that is collected, they may have their own industry-specific requirements. And therefore, to that extent, okay, to that extent, we are able to see the Act recognizing under Section 18(1)(a) that it can be authorized by another law. But also that retention, as we've said from the slide, you can see, it must not exceed the reason or the purpose for which it is being collected. And so retention begins from Section 18 of the Data Protection and Privacy Act. And so always ask yourself, one, what is the purpose for which we collected this data? And how long do we need to keep that data to achieve that purpose? Two, is there a specific sector-based law, okay, that tells me a minimum period by which I should hold this data and a maximum period? Okay, so that's sort of the starting point. But also, as we go ahead, even when you are retaining, the data subject must consent to the period for which you are providing. Okay, so if it is not a requirement of the law and it's a specific purpose, I always recommend in the privacy policies and in the forms that are being drafted, put a specific clause that they consent, okay, to the fact that this data is going to be collected for this purpose and it shall be retained for 5 or 6 years. So as opposed to even, so don't hide the length of the period. And I think one of the key outcomes from this webinar should be as you draft these policies, as you advise the boards, I know most of you are data protection officers, your technology officers, recommend that this period is stated clearly in the data policy or in the consent form. Okay? So circumstances where retention and consent may not be required are one, if it is required under the law. For instance, as I'm going to tell you, in the banking sector, in the insurance sector, in the medical health sector, you're required to hold this data for a minimum period. In such an instance, you may not need consent as a question for retention of the data because the law requires you to hold that data for a certain period because of certain interests that public interests that are drafted in the law. If it's for the performance of a public duty by a public body, for national security, and all these are listed under subsection 2, okay, of section 18 of the Data Protection and Privacy Act. And I hope we can follow. Okay. So we'll continue. So specific purpose is important, and minimality. These are outlined through the Act on various occasions. So collection and retention must be for a specific purpose. And even Section 18 says, if you are retaining data, you must retain it for the purpose for which you collected the data. So you always have to think about a minimal perspective of if you need the data for this purpose, what's the least time that you may need to hold that data? So you're required to state the period for which data will be retained. Okay? Now, as I said, some sectors give you a minimum period. Some do not. If they do not, you must think about the specific purpose for which this data is being collected and how you can streamline that. So in the next 15 minutes, I'm going to speak about certain sectors because now we've understood that the legal regime on retention of data comes from the overall framework on data protection, but specifically Section 18. One, it must be for the specific purpose. If it's not for the specific purpose, it must be authorized by the law. Now, certain sectors or industries, and that's why this webinar, which has been organized by the Personal Data Protection Office, is focused on the circumstances of industry-specific regulations and standards. So I'll focus a lot on regulations because as a lawyer, and I deal with rules, with regulations, and those regulations sometimes prescribe the standards that ought to be followed. So in the second half of this presentation, I'll speak about the banking sector, the insurance sector, the telecommunication sector, and health. Now, there are so many other sectors, but what I have seen from my practice of this area of law is that most of the sectors will actually say that the retention of data in this sector shall be subject to the data protection laws of Uganda. That means you come back to the default section of Section 18. So health sector. Now, the health sector is very, very important. As I said, I've always believed that one of the most important professions are the medical doctors, because while I practice law, at some point when I am unwell, if I am unwell, I cannot go to court. I cannot interact with the regulator on behalf of my clients. And health information is some of the most sensitive personal data that can ever be shared. Information concerning your DNA, concerning your health. So the health sector is one, and actually in other jurisdictions, like the United States, they have HIPAA, the Health Information Privacy Act, which is specific on how health data is handled. Okay, so in Uganda, you have to think about the Health Service Commission Act, which provides a responsibility for health workers to follow the law. But most important, and any medical practitioner would know specifically how this would operate. Okay, there is the Patient's Charter. The Patient's Charter is a directive that was issued, that is issued under the auspices of the Ministry of Health, and health practitioners are required to follow it. So in terms of medical records retention, page 9 of the Patient's Charter, which is a guideline that is some form of soft law. So it carries a legal obligation to a certain extent. Okay, remember we began from the point of Section 18, which refers to retain data for a period authorized by the law. So we're now in the health sector. The health sector under the Health Service Act requires health workers to be responsible and to follow the law. And the Patients Charter, which is issued under the auspices of the Ministry of Health of Uganda, we don't have an act of parliament on retention of data in the health sector, but the Patients Charter of 2009 is instructive. So it provides for the periods for retention, which I think are very important. One, in terms of retention of general medical records, the Patient Health Charter recommends 25 years from when they are collected, and if someone has died, 3 years after the death, okay? And then in terms of obstetrics, 25 years after the birth of the child, including a stillbirth, okay? As a bare minimum, that means as a medical institution, you would run afoul of the law if you begin to authorize deleting information, general medical information, after 1 year, okay? So you can't, you are restricted because of the industry in which you are operating. And then in terms of psychiatry, it is that information is required to be retained for the lifetime of the patient, or if someone has died within 3 years after the death. Now, I know that this may sound like it's quite a lot to deal with, but we have to keep in mind the fact that with the framers of this webinar were mindful that there are industry-specific regulations. So we're speaking about the health sector. The health sector is regulated, of course, by the Data Protection and Privacy Act, but because of Section 18, Paragraph 2, which allows for laws to authorize retention, we can go into the Health Service Commission Act and the Medical Retention Records Act. But also beyond that, we have standard operating procedures for health information that have been issued by the Ministry of Health. They recommend how health data should be stored, okay? It should be stored by the year in which it was recorded and in the department for ease of retrieval. So these are some of the industry-specific standards for the health sector. And so I always invite people, sometimes you may not know even these standards, but look up the laws, or ask your lawyers who are advising the company. What are the laws in my industry that overlap with data protection besides the Data Protection and Privacy Act? Then most current files of not more than 5 years should be kept within the records office. And then older files are kept and can be archived. And then it's also more specific because health sector is sensitive, and this whole presentation could be about the health sector. They have specific regulations on disease surveillance and other sensitive medical areas where personal information has been collected. So another key sector that I think would like to point out, or industry specific regulation, is the banking sector. As you all know, banks are very essential to the lifeblood of the economy and the lifeblood of the country. So even as we think about this sector, we have to, one, know what is the requirement within that sector for the retention of data. So when you look at Section 46.1 and 46.6 of the Financial Institutions Amendment Act of 2016, okay, banks are required to retain data for a period of not less than 10 years. Okay, so they have a minimum period because something could happen and they need your bank records to ascertain. Your bank records, of course, I know an argument could be made. Are they personal identifiable information? But they have your account number, they have your name, they have your national identification card. So a fair argument can be made that when someone accesses your bank records, which are attributable to your name, that this can be information that falls within personally identifiable information. Okay? So to that extent, the industry regulations require that banks will retain financial information, and this financial information that they collect usually involves your name, your national ID, and several other information, which can all be used to trace back to you. That information must not be deleted. The minimum period for retaining it is 10 years. Okay, and so you'll find that most banks in their privacy policies will tell you that we shall retain your data for 10 years because there's a significant cost on retention of data. And when you retain the data, as I'm well sure you're aware, you have to secure that data. So it's an ancillary obligation that continues to affect you as a data collector and processor. Because as you retain that data for a longer period, you have to keep on securing it. And so there's a cost element to it. In terms of another sector that's really important is the insurance sector. As you may see from your screen, the insurance sector is critical. Section 160 of the Insurance Act of 2017. One key point I hadn't made is whenever you're thinking about the sector you're operating in, remember who the regulator is. Like I said, for banks, it's Bank of Uganda. So on top of the Personal Data Protection Office, which oversees your data issues, the Bank of Uganda is also there. So in the insurance sector, there's the Insurance Regulatory Authority, okay? And under Section 106, Paragraph 2 of the Insurance Act, the insurance regulator also requires a 10-year period, okay? So that means that when you're drafting your policies, you can't say that you will retain data for only 5 years because the law requires you, as recognized under Section 18 of the Data Protection Privacy Act, to follow the authorized law. The authorized law in this presentation are the industry-specific regulations. In the health sector, we've looked at the Health Service Act. We've looked at the Patients Charter, which requires specific retention periods. We've looked at the Financial Institutions Act, which requires a specific period. Now in the insurance sector, there's a minimum period of 10 years. That means you don't have to explain to your data subject that you want to retain for 10 years. All you can tell them is we are required under the law to retain your personal data, which is being processed for your insurance for a minimum period of 10 years. So that's very, very critical and important. And so that's another sector. We'll speak about one other sector because, like I said, there are so many sectors, and I only have about 8 more minutes before we get into a Q&A. But the Communications Act requires licensees under the UCC Act to collect and process store personal data for subscribers before activation of their service. And that's why, for instance, you're signing up for internet, they'll have to take your name of the company, they'll ask you for certain documents. If you're an individual, certain information will be asked from you. But there is no minimum period under the Telecommunications Act, okay? Under the Uganda Communications, the UCC Act, Uganda Communications Act. So it may vary according to your purpose. I've seen a lot of internet service providers provide for a 5-year period because they feel that's a period with which they can retain this information, okay? And also I've reviewed the model licensing agreement for UCC, and all that the regulator says is that in the subsistence of your license, you should undertake to comply with Uganda's data protection laws. So the telecommunications space, unlike the insurance, the medical, and the banking, does not provide for a minimum. It recognizes that this is subject to data protection laws. When you read the data protection laws, on the other hand, you go and find that the authorization under Section 18 to retain data is premised on the purpose for which it was collected. However, some players in the telecommunications space have obligations. For instance, those that are providing payment systems, okay? And that's because they come within the regulatory ambit of Bank of Uganda. So the Payment Systems Act, for instance, would require people to keep transactional data. And that's why you'll see mobile money operators or companies that are providing mobile money services would retain data for also 10 years, which is similar to what is under the banking institution because the regulator is similar. So these are some of the industry-specific standards. Now, is there a contradiction? I don't think there is a contradiction. Remember, in law, the Supreme Court of Uganda has stated, in the case of Uganda Railways Corporation versus Ekwaru, that specific laws prevail over general laws on matters of statutory application and interpretation. That means the Data Protection and Privacy Act is the specific law that governs data. It should take preference over laws on matters of data collection, unless Parliament intends otherwise. But what I see from Section 18 is Section 18 says retain data for the specific purpose for which you collected it. But it recognizes that there are other sectors that could regulate this further. And some of those we've discussed, okay? For instance, in banking, in insurance, in the health sector. So I don't think this is a contradiction. And always I recommend that when you are not so sure, always consult a lawyer or write to the regulator and ask them, we're not so sure how these obligations overlap. But according to the Supreme Court decision, where there is a sector-specific law, and the Data Protection and Privacy Act is the most sector-specific law on data, you interpret it in a way that is in consonance with any industry-specific regulation. So, what are some of the key things on your to-do list in terms of having thought about this session? One, think about, are you a data collector, processor, or controller? You will most likely work for a collector and a processor as a data protection officer. For what purpose are you collecting that data? That's the first cardinal point to determine for how long we should hold that data. And so you can advise and say, since we are in the business of providing this service, maybe we should retain data for 2 years or for 3 years, okay? But in the event that you're in a sector or industry that is specifically regulated, as we've discussed here, the health sector has specific regulations on what data should be kept on-site and off-site. The banking industry provides a minimum retention period of 10 years. The insurance industry, a minimum retention period of 10 years. So check the sector regulator and read the principal regulations, some of which have been discussed, okay? Are there directives from the regulator requiring how long that data should be retained and how it should be retained? So I believe those are some of the considerations that one must keep in mind, especially, remember, if anything, if we've forgotten so much, I know I've been speaking and going back and forth on some of these issues. Remember, retention is related to collection. So it's subject to the principles of data collection, but retention is specifically governed. Don't retain data for a period that is longer than the purpose for which you collected it. But also don't retain data for a period that is outside that is authorized by the law. When we say authorized by the law, we can look at industry-specific regulations, some of which we've discussed in this session. Some of those industry-specific regulations are in the banking industry, in the insurance industry, in the health sector. There are specific ways that this data is required to be collected. So to that extent, Anita, those are some of the key pointers that I have been able to address. I'm seeing some questions. I don't know if I should respond to the questions or you will guide me through that period, Anita.
Thank you very much, Joel, for that very, very wonderful and detailed presentation. I'll guide you, I think, through the questions. But in case you see something that I miss, you can always point it out.
Okay.
Maybe what was key for me from this webinar is that we need to understand the regulatory regime. We need to know who our principal regulator is, and probably that will help us to be able to answer the question of retention. Now, moving on to the questions. I noticed there are questions which have really been answered from your presentation, but I'll just read them again, maybe for emphasis, in case there is something you want to emphasize on that same question. So one question is about, someone says, with that definition of personal data provided in the slide, that was in your very first slide, does it mean if data collected is de-identified, for example, at the point of collection or later, then the retention provisions do not apply?
That's a very good question. That's a very good question. Thank you, Rogers, for that question. The definition that is quoted is from the interpretation section of the Data Protection and Privacy Act. And for the avoidance of doubt, the provision reads, Personal data is any information about a person from which the person can be identified that is recorded in any form. Okay. Now I understand that de-identification of data is one of the ways that data can be secured. But I don't think that that takes you away from the regulatory purview of the Data Protection and Privacy Act. Because what happens is if you de-identify that data, if someone accesses the data that you've kept and they know how to recalibrate it so that it can be identified, if you are sued in court, the judge is going to ask, even if you de-identified the data, why were you still retaining that data? So there is a possibility, in my opinion, and again, and that's from my reading and understanding the general purpose of the law, that even when you've de-identified the data, which is a way of securing it and minimizing a privacy risk, the retention provisions under Section 18 apply, because I don't see a provision in this act that says once you de-identify data, you are now out of the regulatory purview of the Data Protection and Privacy Act. So those are my thoughts. It's a very technical question, but I believe the retention, as long as you collected the data, you've de-identified it, but you collected it from someone, the law requires that you maintain, you retain it in accordance with the specific purpose or in accordance with another law. So in my humble opinion, I don't think that takes away the obligation of the retention provisions. I don't know if that addresses the question, but those are my thoughts.
Okay, thank you, Joel. The next question is about subject requests. Okay, I think this is a bit outside today's webinar. The Data Protection and Privacy Act and its regulations say response to data subject requests is said to be 7 days. Are these calendar days or working days? These are working days, but Joel, are you being a lawyer? If you want to add, it is open really, if you want to respond to that.
No, I think you've addressed it. And usually in law, whenever there are days defined, whenever there are days defined, one has to think about whether they are working days or not. And in general civil procedure law, if the last day is on a weekend, then you have to push it to the next working day. So I think the intention of the law, I'd have to open the regulations, but I think the regulations are specific. If they aren't, then we go to the General Interpretation Act under Ugandan laws. But I think the intention is that they should be working days. Yeah.
Thank you very much. I think I'm going to be taking like 3 questions. I don't know if that's okay with you.
That's okay.
That we take like 3 at once. Okay. So one is good morning. Is there any stipulated time or period for retaining the customer data? I feel like this is what we've been talking about. The next one is archiving and security of data for longer durations comes with a cost. What does the Data Protection Unit recommend on how to cater for such costs? And then 3, what is the recommended retention period for any other data processors such as KYC, KYB, and background check companies? And then maybe, Joel, before you come in, I've noticed that people keep asking about the different sectors. Now there's someone asking about how about for the NGO sector, how about for hospitality sector? I don't know how you're going to be able to go about that. There are many questions asking about specific sectors that we've not been able to look at.
Okay, very, very, very good. Thank you, Anita, for those questions. One, the question from Sharif that is about, is there any stipulated time period for retaining customer data? So the Data Protection and Privacy Act, Section 18, okay, says that data must not be retained for a period longer than the purpose for which it was acquired. So that period is not predetermined. The law doesn't tell you what period. Okay, that's the first starting point. The second arm of the answer to that question is, depending on if there is a sector-specific law, and that's why Section 18, subsection 2, provides for if on the period you're authorized by the law. So for instance, what's customer data? If it's customer data for a bank, a bank is required to retain that information for 10 years. Okay, so your question is very good, but I believe it depends. Where the sector doesn't have a specific regulation, then you have to link it to the purpose. And that just depends on the purpose of the business or the principal business of the entity that you are advising. And I hope that that's a brilliant question. But like I said, I'll give you the lawyerly answer that most lawyers will give. It depends. It really depends. But Section 18 says that when you retain personal data, which I believe customer data would qualify as personal data, retain it for the period that doesn't exceed the specific purpose for which you're collecting it. Then the next question came from archiving and security of data for longer durations. Comes with a cost. What does the data protection unit recommend on how to cater for such costs? Okay, that's a very good question. I'm not sure if I can give you a general comment. I think I said earlier in the presentation that obviously this retention, where it is required by the law in certain sectors, keep it for this period, you have to find a way of factoring that in a cost of business. And I feel that's a much more business developed question. So that means as you design your business model, you must be able to factor in how you retain this data and secure it, or how you will archive it and keep it secure. So that sounds more like a business-based question. But in terms of the legal obligation, the moment you know the period for which you are required to retain the data, or after assessing the purpose for which you're collecting the data, and you say this is the period for which you will keep it, that's as far as the legal obligation stipulates. But maybe the regulators in this space could address, but that sounds more like a business question, which may not be entirely within my competence to answer. And then what is the recommendation period for data processors such as for KYC and background check companies? I think that depends on your purpose and who you are serving and the purpose for which you're collecting, which is the premise under Section 18. But I think that reasonable periods could range between 3 to 6 years. But again, that depends within the purpose. If your KYC is in relation to financial transactions, I would say stretch out that period longer, okay? Because financial issues always, there are more disputes that come up. And I think that's the underlying undertone behind these sector-specific regulations, and to that extent. So the other arm of the question, which was really posed by Anita, was there are so many sectors. And when I was preparing for this webinar, I was thinking about how can I address most of the sectors. So most of the sectors in Uganda, for instance, they don't tell you, for instance, the telecommunications sector, the regulations there under don't tell you how long you should retain data. So in the event that they don't tell you, and this is the answer to all those specific questions, okay, you have to go back to the Data Protection and Privacy Act, which is Section 18. Okay, Section 18 says for the purpose for which it is being collected. Okay, if your organization is aimed at, for instance, raising children and taking them to school and giving them certain amenities, the specific reason why you're collecting their data may require that you hold it over a longer period. Okay, so that could be the period that you subscribe. So out of the limitations of time, I couldn't address all sectors, but I'm very well aware that the sectors that have specific regulations on how long you should retain data are minimal, and most of which I have discussed. The telecommunication space, their law doesn't tell you. Okay, in fact, licensees are told in all instances, go back to the Data Protection and Privacy Law. And that's why this law was being drafted very carefully, because you don't want the government restricting you too much on how you can retain data. So the law gives you discretion in accordance with the principles of relevance, accountability, and specific purpose. So to that extent, those are some of the answers, my answers to some of the sectors which obviously we could not cover fully within this presentation. Now, for instance, there's a question on fintechs. Fintechs, if you are a fintech company, depending on who regulates you, but fintech companies that are licensed as payment system providers, that are licensed by the Bank of Uganda, are likely to be required to retain data for a period of close to 10 years, which is similar to financial institutions. Okay? So your question, Damaris, I think is very important. And I hope that this helps you. So, Anita, do you want to take over? I try to address some of the 4 questions.
Okay, thank you very much. Now, in relation to that 10 years you just talked about, someone said, please clarify about the stated 10 years of retention of personal data because it's not clear. If I'm holding a bank account and I'm still alive, what happens after that 10 years if I still have the account? Is that data kept for additional 10 years or after account closure or death? And
okay,
then, should I take 3 more or you want to first respond to that?
No, you can take 3 more.
Okay. Could you please share a bit on fines and penalties and whether the DPO has enforcement powers of this? I don't know if this is talking about if you're in violation of Section 18. Maybe you could answer in that regard. And then consider a data collector who does not operate in a regulated sector and collects data for various reasons. So the retention period requirement varies. The PDPO portal only requires a single response to the period for which data is retained. This is a challenge. Could you please specify on what you mean when you say the PDPO portal only requires a single response for the period in which data is retained? Maybe if you can clarify that, I don't know who asked this question, we'll be able to provide feedback.
Okay.
Okay, right. Over to you.
All right, thank you very much, Anita, again. I think these are very brilliant questions, very engaging questions. Thank you to the audience for asking these very live questions. So one of the earlier questions on the 10 years retention was in respect to banking institutions and banks under the Financial Institutions Act. I believe that was section 46. Section 46 of the Banking Institution Act requires them to retain data for up to 10 years. But I believe the interpretation of that provision would include 10 years from the period on which the account may be closed or ceases to operate. Because we've done some cases where some financial institutions have been sued. And actually the dispute was what's the extent of that obligation. And the obligation is those 10 years period would lapse they would begin to run from the period from which that data, again, I stand to be corrected, from the period from which that account has been closed. So if the account was closed in 2020, there might be an ancillary obligation because disputes come up that you keep that information for up to 10 years. I was trying to reopen the provision so I can read it out loud so we can interpret it closely. But I think that's sort of like the input from the provision of under the Act. In terms of the next line of questions, let me just scroll and see. In terms of the next question, could you please share on fines and penalties? Yes?
Yeah, I think it was that question about fines and penalties. Yeah.
Yes, so once one does not comply with the Data Protection and Privacy Act, they may be prosecuted. So the fines and penalties that could be imposed on them will apply after they've been prosecuted for failure to comply with this law. Now, this is a different approach from other countries. Their regulators can issue those fines. But in my reading and understanding of the Data Protection and Privacy Act, the extent and the part that deals with fines is included under I would invite you to look at offenses. That's part 8 of the Data Protection and Privacy Act. It provides quite clearly that in instances where people have violated the law, the obligation lay on they've committed an offense. So a person who contravenes, for instance, a provision and they've unlawfully accessed data, commits an offense and is liable on conviction. And that's the language for most of the violations of the provisions under the Data Protection and Privacy Act. So what is likely to happen when you violate? The DPO has enforcement powers to prosecute you, and under those circumstances, you could be fined. There are certain provisions where you can be fined up to 2% of the gross income of the company, but most of the provisions actually have criminal liability. So as people who are sitting, who are operating in the offices of data protection officers, you should take your job very seriously, because there's a possibility that the company can be fined upon prosecution, and 2, that as an individual, you could be held criminally liable, because there's a requirement that anyone collecting data, any collector processor must designate a data protection officer. Once you are designated, that's why I think it's always important. This law, the Data Protection and Privacy Act, lists out the obligations that you have to do. Understand them carefully. If they are saying retain data for a certain period, which a sector regulation is saying, once you breach it, you're breaching the law. And the breach of the law comes with consequences. So, David, I think it's a brilliant question. Yes, there are enforcement powers, and penalties may be imposed, some of which include fines and imprisonment, actually. You can be imprisoned for some offenses for up to a period not exceeding 10 years, but that's after prosecution. So I hope that addresses your question. And then the next question was consider a data collector who does not operate in a regulated sector and collects data for various reasons. So the retention period varies. The PD report only requires a single response for the period which data is retained. This is a challenge. I think you pointed out a good point. And I'm sure some of the officials from the PDPO are here. And I think this is something you can engage. So I'd encourage you to engage, write to, I think, manager compliance and ask this question, because I might be, I can't make a pronouncement on behalf of the institution. I'm here as a private player, merely to share knowledge. But I think that's a good point, because the purpose, as we say, Section 18 regulates the specific purpose for which you're collecting data. You only retain it for that purpose. And if you're collecting data for different purposes and it varies, then I think you might want to engage the regulator to see how the portal can be adjusted to allow you to put in different retention periods for the different purposes for which the data is being collected. Yeah, I think we've almost hit the 1 hour mark, and I think that this session for me has been quite helpful. These are all brilliant questions. I don't know if there are any other questions.
Joel, we still had many questions, but given the fact that we are running out of time, if it's okay with you, we can just take like one more and then close, and then encourage the rest of the people to just share with us the questions on email, and then they will be responded to. I've noticed so many people asking questions related to registration and other things. We are not really ignoring those questions, but kindly channel them directly to us, to PDPO, our usual email, info@pdpo.go.ug, and you'll get a response. Joel, can I take maybe one more?
Yeah, that's fine.
We have only 1 minute. There's a question. Someone said, with the embracing of digital health in the health sector currently, the digitalization journey in health is still young, like literally taking off. Do we have any regulations or rules that govern digital health? Over to you.
Okay, thank you, Patrick, for that question. I think it's a very good question. Like most sectors, there is a lot of digital advancement. For instance, even in the health sector, there's telemedicine now. People are offering, practicing medicine virtually, and they are giving advice to different people. So I'm very well alive to the fact that there's now digital health provision of services in the health sector. And the digitization journey in health is still young. So I'm not aware of specific regulations on digital health. For instance, I know for a fact that digital financial services like fintechs, now those are regulated under the Payment Service Providers Act that is regulated by the Bank of Uganda. But I'm unaware of specific regulations that govern digital health. Patrick, I think that's a very good question. So in the absence of those specific rules, until they are made, I always advise people apply the regulations as they are. So if you're providing a digital health framework, we discussed some of the regulations under the health sector. We looked at the patient's charter. If you're providing a health service, you might be a health worker. So we need to be able to look in how do we interpret those clauses. If you offer digital health and you're collecting personally identifiable information for your patients, I believe the patient charter for now still applies to you. We might battle over how we apply it digitally, but I think the law still applies until the House of Parliament passes a new law. So I'm not aware of specific regulations, but even the premise of my discussion is that the general regulations on health, some of which we discussed, would extend to you, although they may not be perfectly in sync with the digital health solutions that are being provided. That's when we need to play an advocacy role, that we have more sector regulations. Because in countries like the United States, their health sector, whether digital, it's so heavily regulated that even when information is shared on digital applications, the legal regime is still quite strong. So, Patrick, I think that's a very thought-provoking question, and I hope I've addressed it to a certain degree.
Okay, thank you so much, Joel, for that response. And thank you very much for today's presentation. It has really been very, very insightful. And of course, from the PDPO, we thank you for always being available for us whenever we call upon you. Thank you for always honoring our invitations. And of course, the participants, thank you so much for always making the time for these monthly webinars. I have shared a link in the chat. Please click on it for the participants and give us feedback. The feedback you give us will help us to make future trainings better for you. And Joel, do you have any parting shots before we close?
Yeah, no, thank you very much, Anita. Thank you once again to the PDPO for hosting me today. It was such a distinguished honor. My last words are to our audience. One, whenever you're thinking about data retention, think about what's your legal requirement. Your legal requirement is twofold. One, you can only retain data that for a period that does not exceed the reason for which you collected it. So there's some internal thought process that you must engage with other stakeholders in the company. For how long do you really need this data? And keep in mind that retain and collect data specifically in a minimality sense. The second is, and this is the second key takeaway, in the sector you're operating, are there specific regulations? We've looked at some for the specific sectors. So find out, what does our regulator say? What does Bank of Uganda say? What does the Insurance Regulation Commission say? What does the Ministry of Health say? Have they issued directives? So that's the mindset that is important. And whenever you're unsure, please always seek legal counsel. Because again, I understand it's not very easy to find what the law says. And that's why, of course, lawyers are trained to read the law, read the regulations, and interpret them. So seek legal counsel where you're unsure. But otherwise, it's always, this area is ever evolving. And that's why I think we had so many questions in the chat room. The answers sometimes are not clear, because even I myself as a lawyer, I'm constantly researching, how do we interpret this provision? How has it been interpreted in Europe? Okay, how has it been interpreted in Kenya? Then I can advise my client on how to deal with that issue. So to that extent, please keep those two things in mind, but always ask questions, and sometimes people who are legally obliged to advise you on some of these questions. But otherwise, it's been such a great honor. I remain Joel Basoga, and my practice is really focused on data protection. And thank you, Anita, and thank you to the Data Protection Office for inviting me here. It's been such a great honor to be a part of this conversation.
Thank you so much, Joel. It's been a very great pleasure having you today. I think you had earlier shared a slide with your contacts and everything for those that may want to reach out to you on regarding maybe advice or anything to do with retention. I just hope that everyone has been able to pick those contacts. Thank you so much. Have a wonderful day. And for the participants, see you again next month.
Thank you. But I've also shared a link to my website. All my contact details are there in case someone wants to ask a question. I'm happy to engage. Thank you very much.
Okay, perfect. All right.